Hello, this is Joseph Flory with the Barron C. Metz School of Common Law. And I would like some feedback on what we're doing, if the subject matters or even matters to you anymore. I know it does to me. But you can contact us at dueprocessexplained@gmail.com. For any questions, would appreciate it. What I'm going to do, this is probably more of a preliminary of getting started on the subject of due process. One of the things that we need to make clear is that there's been a difference in due process, mainly since the Civil War, probably just all since the Civil War. I'm not sure mainly is a correct word there. Due process has been known to be synonymous with the term law of the land. Now, in the Magna Carta, where we can originate, not the phrase due process, but we can originate it with the Magna Carta, chapter 29, where it talks about that no one would be deceased of their freedom, etc. I'm not going to quote it because I couldn't anyway. I'd have to read it. But we're going to look at it that they use the term law of the land. Now, some 100, probably 30 years later, I'm not sure the exact math there, the Magna Carta was in 1512, and by 1215, and by 1337, I believe, is when Parliament in England passed a statute that was identical to the Magna Carta. The exception was that while they quoted piece by piece and word by word of the original Magna Carta, when it came to say the law of the land, it used the term due process of law. Now, this was taken to be believed to be synonymous terms. Sir Edward Coke made that clear in his writings that due process and the law of the land were synonymous terms. And so, if the law of the land is synonymous with due process, then you also need to know what is the law of the land. Well, the law of the land is the common law. So, if the common law is the law of the land, the due process is the common law. And many cases, I can think of one right off, Hope versus Henderson, that's found at 25, North Carolina 25. It plainly states that without the usage of the common law, you have not received due process. Now, this is what we'll be learning in the future about whether you're in a court that's actually allowing the common law, which is the law of the land, not some of these little statutory regulations that conflict. You know, statutory law should complement the common law. It should not have any contradictions to the common law. If so, we have plenty of cases that will tell you that it's repugnant to the Constitution, which, by the way, also backs up the common law. And so, if it's in contradiction to the common law, then it's to be repugnant, void, and etc. It just don't exist, has no legal reality, and there's no reason for us to make any allegiance to it or go by it. And of course, these courts that are like traffic courts, and especially all the administrative courts, they wouldn't even think of going by the common law. They don't mind telling you straight out, no. Which means for sure that they are not providing due process, because remember, due process, common law, law of the land. Now, an interesting turn of events that helped, I think, promote the change of the idea of due process so it could be changed was the fact that uh, most of the states' constitutions before the war had, well, they did. There probably was only one or two that even used the term due process, if any. I'm vague on that right now. But their normal phrase in their constitutions was the law of the land, uh, the uh, uh, the law of the land, and similar phrases that meant the same. But the thing I want to bring out is that since all the constitutions of the states before the Civil War used this term law of the land, uh, after the Civil War, and it would be probably interesting if some of your own groups would go to your own states and locate if your state ever had a constitutional amendment moment to where they actually changed their constitutions, or whether it was just done. Either way, it supports the idea. But here's what we're looking at. Johnson wanted all the constitutions of the states to use the word due process in place of law of the land. The motive behind that, I don't know. I mean, I don't know what Johnson thinks. But it's clear that the law of the land, I don't know how you would play with that meaning and term. I don't know how it can be done. 100 years could go by and the law of the land would still imply and make note of the law of the land. I mean, I wouldn't know how to go any further. But that due process now can be played with. Now, when Johnson made this point to, I don't know if they decreed it or he asked them, but all the constitutions of the states complied. They immediately did it. Whether they did it lawfully or not, I don't know much was happening lawfully back then anyway, with the tyrants and the Union. The new Union then was taking over and shoving everybody around and destroying their farms and plundering everything they had. And of course they were here to protect and to be for you. And to this day they're still here to protect and be for you. And so we know what they mean now when they're here to protect. We need more police power, we need more of everything. So what we are wanting to get clear is that due process has been changed to the courts. In fact, they actually even came about. In a case called Hurtados versus California. I believe that was 1880, the first criminal case after the war. And that's a long story to get involved with that, but that went to the Supreme Court to be reprimanded over the due process, at least the first due process clause case. And of course, you know, they had, in California, had denied a grand jury indictment. And so the lawyer went and argued that that would be a violation of due process. And of course, the Supreme Court of that time, after the war, and you should expect what they would do and what they've been doing, is diminish the meaning of due process by stating that that a grand jury indictment was not necessary in this case, even though it was. And of course, their idea was that as long as the rest of the trial is fair, no big deal about the indictment. It's more of a procedural nothing. Well, see, this is the beginning of the end of this, because due process before the Civil War was procedure, proper writs, absolute in order. Your ducks in a row, as they would put it. You don't go to a home without a warrant signed with an affidavit, a signed affidavit, not just a warrant that says we can search your house. Somebody better be on that paper that is an affidavit to the facts. before the warrant can be issued. They don't do that anymore. If they do, I'm not aware of it, but who cares? Right now we're going to show what due process was a little bit for us to get this going. When we do get into the actual quotes, and which I've got plenty of notes, and I'll just read right out of the books. But with these changes going on, that all the state constitutions were just wiped clean of the old term law of the land, is interesting to me. But it does at least prove one good point, is that law of the land and due process was synonymous, and maybe synonymous so much that it didn't require a convention. It didn't require each state to just go before the legislatures and get this amendment redone into their constitution. Maybe they did feel like it was that extremely together, synonymous, that changing that doesn't require anything. If that's the case, that's fine, because it is that synonymous. Law of the land, due process. Said by Sir Edward Coke, taught by Blackstone, understood by Franklin and all of them that helped put this convention together. So we do know what due process means, and you cannot take life, liberty, or property without providing it. So we will study the future where they had, they've actually invented a term, and of course there's plenty of other inventions. I'm just want to bring out more so the one called substantive due process, which was invented in 1947, and they make it sound like it's always been there. It has always been there. And they quote a couple of cases they claim was using it, and what they're talking about is some kind of a style of the way they looked at due process. And of course they got me. I've tried to listen to how they claimed it was there, and I'm trying to see that. So okay, maybe I'm the blind one here. But one thing that still sends my suspicions is that due process is going down the tube. So I'm not sure I'm willing to be admitting I'm blind to something here. If that's all they can say, then they got a problem. And if that is their defense of this new term, substantive due process, which is now being used over procedural due process, which was the only due process understood before the Civil War, then that's where we're at. You know, the Internal Revenue Service and a lot of other agencies, they have their definitions. You know, they've invented probably about 10, 15 years ago or better what is called due process hearing, or some kind of a hearing due process right that you've got to a hearing. And a hearing to what? To them? To their courts? To their administration? Do I really want the bully on the block to set up his people that I need to go to get my football back? And do I really need to go to the people and call it a hearing? And of course, you know, part of the definition of due process is notice and opportunity to defend and to a hearing. And so, you know, when you play with these words, let's make sure that we're still before the judiciary. This is what I will be, putting emphasis on, is before the judiciary, not an administrative court, legislatively enacted, or executive. I mean, there's some of these people out there executively appointed, and they have their courts. Really? And of course, it's their courts. And you probably heard plenty of times, judges, you don't say this in my court. And you know, there may be a lot of truth to that. It probably is their court. In a constitutional speaking manner, that would be erroneous for them to say that if this was a real court that actually belonged to the people. But we know that it doesn't, because it's, first of all, it's administrative. It's created by the legislatures. It's a executive appointed deal, or one way or the other. You know, it's a court that is not actually possessed with the virtues of the judiciary powers. So I'm going to close it out. Keep this thing short. Give me feedback and let me know at dueprocessexplained@gmail.com, and we will do our best to answer your questions. Thank you. Until Shiloh comes.